Good morning. I'm Gary DeWaal, and this is Bridging the Week for August 12th through 16th, and today is August 19th, 2019. Last week, two food giants agreed to resolve charges brought by the Commodity Futures Trading Commission that they manipulated or attempted to manipulate prices of the Chicago Board of Trade's December 2011 wheat futures contract and spot wheat by consenting to pay a $16 million fine and acquiescing never to violate certain provisions of law in the future. Very unusually, the CFTC did not include any findings of fact or conclusions of law in the consent order and separately agreed not to discuss this case publicly. However, concurrently with publicizing the consent order, the CFTC published a press release and certain statements that the food giants promptly challenged as violating the terms of the order. Separately, the Securities and Exchange Commission resolved an enforcement action against a healthcare industry blockchain company over a purported unregistered digital securities offering. I am still out in Colorado for the next few weeks, and it's been glorious to watch morning sunrises and evening sunsets framing the Rocky Mountains in purple color majesty. So I can get back to my daily job, however, let's get started. Last week, Kraft Foods Group and Mondelez Global agreed to settle the 2015 complaint by the Commodity Futures Trading Commission charging the firms with manipulating or attempting to manipulate the price of December 2011 wheat futures contract traded on the Chicago Board of Trade and cash wheat by payment of a $16 million fine. The CFTC also charged the firms with using a manipulative or deceptive device or contrivance in connection with the same futures contract, exceeding applicable speculative position limits in connection with their holding of the December 2011 wheat futures, and engaging in wash sales in connection with trading both sides of exchange for physical transactions at various times from 2009 through 2014. In agreeing to the settlement, the CFTC and the defendants acquiesced not to make any public statements about this case other than referencing the settlement agreement between the parties and public documents filed in the matter. This agreement was formally codified in a consent order. The consent order, unlike other typical CFTC consent orders, also did not contain any factual findings or conclusions of law. However, concurrently with this announcement of the settlement, the CFTC issued a press release summarizing its complaint against the defendants, including a comment by new chairman Heath Tarpert regarding the harm of market manipulation to farmers, and a statement that, quote, the $16 million penalty is approximately 3 times defendants' alleged gain, end of quote. The CFTC also released a statement of the commission and a joint statement by Commissioners Dan Berkovitz and Ralston Benham. Subsequently, the defendants requested an emergency status hearing before the judge presiding over the matter, alleging that the CFTC violated the terms of the consent order and should be held in contempt and or subject to sanctions. The judge scheduled a hearing on these allegations for August 19th. In addition to agreeing to a monetary settlement, the defendants consented to entry of an injunction prohibiting them from future violations of the relevant provisions of law charged in the complaint. According to its terms, the consent agreement does not constitute, quote, an agreement or a legal determination that defendants have or have not violated any provision of applicable law, end of quote. The decision of the CFTC to acquiesce to a gag order applied to both defendants as well as itself, and its agreement not to include express findings of fact and conclusions of law in the consent order is highly unusual. Although the amount of the fine and the injunction against future violations incurred by the defendants is onerous and sends an important warning to the industry, the Commission's agreement not to provide insight into its thinking, either in the consent order or through official public comments, is counterproductive and undercuts any intended message. The outcome of the August 19th hearing may also add additional oddness to the resolution of this matter. I have a lot more to say on this settlement in the article version of Bridging the Week at www.bridgingtheweek.com. Check it out. And finally, Simply Vital Health, Inc. was assessed no fine by the Securities and Exchange Commission to settle an enforcement action alleging that it engaged in an unlawful securities offering without registering the securities when it offered and sold digital tokens to raise funds for a new venture in 2017 and 2018. The firm consented to a cease and desist order and agreed never to violate any U.S. securities registration requirement again. According to the SEC, during the relevant time, Simply Vital sought to develop a blockchain-based system, Health Nexus, through which healthcare providers could share patient data. To accomplish this, it organized a sale of a proposed new digital token known as Health Cash, or HLTH, which ultimately would be used as the currency on Health Nexus. Although Simply Vital planned a pre-sale of Health Cash solely to so-called accredited investors relying on an exemption from registration, the company did not take quote-unquote reasonable steps to verify that purchasers were appropriately qualified, claimed the SEC. Moreover, the SEC said that Simply Vital expressly solicited investors through general solicitations, quote, including through internet postings and direct communications with U.S. postings, end of quote, U.S. persons, end of quote. The SEC has treated gingerly firms that engage in what it considered unregistered digital securities offerings, provided no fraud was involved and the entities returned raised funds to investors, among other remedial measures. For more on this, check out the article version of this story at you know where, www.bridgingtheweek.com. Well, that's it for this week's edition of Bridging the Week. As always, there is more commentary on the article version of Bridging the Week at www.bridgingtheweek.com. Check it out. I'm Gary DeWaal, and until the next edition of Bridging the Week, have a great week, and ciao.